the junior claimant, Manisha Jain, will be taking 18 minutes and 5 minutes will reserve it for rebuttals.
Okay. So you said how many? Sorry, you said for your own main presentation.
22 minutes, Your Honor.
22 minutes. Okay. And
junior claimant.
And in rebuttal.
Rebuttals 5 minutes, Your Honor.
5 minutes. Okay. And your junior will be also
18 minutes, Your Honor.
And your junior is
Manisha Jain.
Manisha Jain. Okay, so 18 minutes for the presentation and rebuttal. How long rebuttal?
5 minutes, Your Honor. 5 minutes.
5 minutes. Okay, so that's for the claimant. Okay, how about the defendant? Defendant? Who is the defendant? Who is here for Amity University? Do you hear me? Do you hear me?
Yes.
Diametaz, are we audible?
Yes.
Yeah. Request you to please turn on your camera.
Mike, okay, let me rejoin. It might be an IT issue. Admin, are you here?
Yes, we hear you.
Well, I don't know why my camera.
And we see you also.
I selected video on. It worked perfectly in the previous round, but since nobody sees me.
We see you, Rodrigo. We see you.
You see, okay. Very
no
strange
problem.
because I don't see myself.
Not a problem.
Okay. Okay, so who is for the defendant? Amity University.
Yes, good afternoon. I'll be the senior counsel for the defendant.
Isra Zaidi, okay?
Yes.
You're the senior counsel for the defendant?
Yes.
Okay, and so can you tell me about your time allocation?
Our time allocation will be 16 minutes for our oral submissions, 5 minutes for rebuttal, and the same allocation will also be followed by my junior co-counsel.
Who is?
Dia Miraj.
Dia Miraj, okay. Not see Dia here. Okay, 16 minutes and 5 minutes. Okay. Thank you. I think we can proceed with the claimant. Character, sorry, what is your surname? I cannot see your surname in the. What is your surname?
Claimant's surname, Your Honor.
Your surname. Your name is Kirti. I can see Kirti, but what Kirti? Sorry. What
Kirti
is your
K.
surname?
K, Your Honor, just the initial Kirti K.
Kirti K. Okay. Okay, Mr. Kirti K. You can start.
Indeed, Your Honor. Your Honor, if you're well versed with the facts of the case, can the counsel proceed with the arguments of the case?
Sure.
Much obliged, Your Honor. Your Honor, the first issue is regarding the claim, that is Solar Dreams' liability to Mr. Atrocia in tort and for breach of contract. Your Honor, for the convenience of the court, I'll be dealing with this issue in two parts. Firstly, regarding the liability, Solar Dreams' liability in torts, and secondly, Solar Dreams' liability for breach of contract. Your Honor, the counsel submits that there is a gross negligence and willful misconduct by the Canadian space flight company Solar Dream, which has led to Artemis contracting COVID-19 and subsequently to abort the space mission. Your Honor, Article 17 of DIFC Law of Obligation states that a defendant is liable in negligence to a claimant if he owes a duty of care to the claimant, breaches the duty of care, and thereby caused loss to the claimant. Your Honor, these are the 3 points that I'll be substantiating to prove gross negligence and willful misconduct on the part of Solar Dream. Firstly, Your Honor, lack of duty towards Astrocia. Your Honor, it is submitted that Solar Dream failed to provide sufficient duty of care towards Artemis in their star-aligned space yoga retreat. According to Article 18 of DIFC Law of Obligation, the defendant is obligated to exercise sufficient duty of care towards the claimant, failing which it is mandated to compensate for the loss caused to the claimant. In Donlog versus Stephenson case, it was clearly stated that a person must take reasonable care to avoid acts or omissions which would likely injure another person where it is foreseeable that such an injury could occur in the given circumstance. Further, Your Honor, it is not, of course, a duty of insurance against the claim, but a duty of care, duty to take reasonable care to avoid the harm from being suffered. In the case of Taylor versus Cadwell, the court observed that there seems no doubt that there is a positive contract to do a thing. The contractor must perform it or pays damages for not doing it, although in the consequence of unforeseen accidents, the performance of his contract has become unexpectedly burdensome or even impossible. However, Your Honor, in the present case, the defendant, owed the duty of care toward Astrocia, could foresee the repercussions of the circumstance arising out of COVID-19. But however, Solar Dream willfully misconducted in carrying out the mission and failed to provide duty of care in lieu of the spike in Vulcan variant. Secondly, Your Honor, there is a breach of duty on the part of Solar Dream. It is submitted that defendant breached the duty of care towards the claimant and caused gross negligence in executing the space mission. Further, in order to establish a duty of breach of duty on the part of defendant, it is important to fall within the ambit of standard of care, which is likely to be taken by a reasonable man. But in instant case, this too has been defaulted by the Solar Dream. Your Honor, Article 21 of DIFC Law of Obligation provides that reasonable care means the care which a person of ordinary care and skill engaged in a type of activity in which the defendant was engaged would have exercised. In the instant case, Your Honor, firstly, the defendant...
Sorry, Counsel, can you so you said 22, Article 22?
21, Your Honor.
21.
Yes, Your Honor.
Okay, and so you said that the standard here is the standard of a reasonable person.
Indeed, Your Honor.
Okay, but isn't the case here that everybody was tested? They did what I think what is called a rapid test, and that was negative, and then they also did a PCR test. But that's reasonable. I mean, if you adopt a reasonable person standard, it's reasonable what they did, isn't it?
Your Honor, there were not only in the conducting of the COVID-19 test, but also in many other circumstances, the Solar Dream has violated the mandates mentioned in the agreement. Specifically talking about the COVID-19 test, this lateral flow test was not completely accurate to proceed with the space flight mission. That too in the given in the special circumstances of rise in COVID-19. The company could have waited till they receive the PCR test and then proceeded with their space flight mission. Your Honor, I'll be further substantiating upon all these points in my further submissions.
Yeah, just to conclude this point. So understand about the we will be asking about the historical context. You explained to me now that the context was about another wave of COVID. I understand, but I'm interested in the standard. Right, the defendant is a company. It's not an individual. It's a professional. But you're happy to submit that the applicable standard is that of ordinary care and skill. So the same standard that would be applicable to an individual. Let's say if I'm going on a trip with my family and I don't test my family for my son and my wife for COVID, but then it happens that as they test them for PCR, they will have COVID. So you're saying that the company has the same standard of care, same responsibility that they have as a private individual.
Your Lordship, the company has a more liability than compared to ordinary man, because here they are undertaking the space mission for a group of 10 passengers, and also with the special circumstance of rise in COVID-19, even if considering the perspective of a reasonable man, they couldn't have just relied on the lateral flow test. They should have taken the PCR test, which was more accurate.
Okay, I know. So I want to understand the standard. So you're saying that the standard is a different standard than the standard of a private person.
Indeed, Your Lordship.
Okay, and what is the source of this in Article 21?
Your Lordship, this lateral flow test was insufficient given the situation of.
Ask about what is the legal authority to attribute a higher, heavier standard? What is the authority that allows you under the DIFC law to use a higher standard? It's a legal question. I'm not asking about the facts. I know the facts.
Your Lordship, can you please pardon it?
We discussed that in some circumstances, and we said that those circumstances are present here, the SC law allows you to use a standard of liability, standard of care, which is higher than the standard of care of a private person.
Indeed, Your Lordship.
Okay. Is there a legal ground? Is there a rule in the law of obligations that explains that sometimes you have a special standard?
Your Honor, the Article 21 talks about reasonable care that should be taken.
Mm-hmm. How about 21.3?
Of DIFC law of obligations.
Yes. How about 21, paragraph 3?
Part?
Can you read it? How about paragraph 3? Paragraph 3 of Article 21.
Indeed, Your Lordship, in this circumstance as well, a professional person exercises reasonable care if he shows that the standard of an ordinary skilled person exercising and professing to have the special skill in question.
Mm-hmm.
In this case too, Your Lordship, the company was obligated to take an extra effort in assuring the safety of the passengers.
Okay, thank you.
Much obliged, Your Lordship. Moving on, Your Honor, in the instant case, the defendant firstly failed to take due care in the wake of contagious Vulcan variant of COVID-19, and secondly, it did not take proper regulatory approvals by neglecting the results of PCR test. Therefore, the Solar Dream oved a standard of care which wasn't fulfilled in the due course of its conduct and thereby breached the duty, leading to gross negligence. Thirdly, Your Honor, this also led to consequential harm to the claimant. Your Honor, it is submitted that the lack of duty of care and the breach of duty have collectively led to Astrosia contracting with Vulcan variant and thereby causing significant harm to her life as well as to the passenger's life. Article 7.4.4 of Unidroit Principles provides for foreseeability of harm. It states that non-performing party is liable only for harm which is foreseen or could reasonably have foreseen at the time of the conclusion of the contract as being likely to result in its non-performance. Further, Your Honor, the concept of
Sorry, counsel. You're relying on the UNIDROIT principles, right?
Indeed, Your Honor.
Is this article of the UNIDROIT principles also incorporated in the contract law of the DIFC?
Indeed, Your Honor. This is a parent act that had the DIFC contract law has been derived from the principles of Unidroit.
Yeah, but this particular rule, and I'm asking this because what the DIFC authorities have done when they issue the contract law, they've taken the Unidroit principle 1994 as a starting point. But some principles were adopted entirely, some principles were amended, some principles were excluded. Which one is it? So this principle, you are relying on your principles. Is this particular principle, this particular rule you're referring to, is this part of the contract law?
Indeed, Your Honor. Paragraph 19 of the Moot proposition states that tort law in the DIFC is codified in the DIFC law of obligations, and contract law in DIFC is codified into the DIFC law, DIFC contract law, and the contract law is based on the Unidroit's principle of international commercial contracts.
Yes. Okay. So, can you tell me what is the principle you quoted now for the Unidroit? You quoted a specific number, right?
7.4.4, Your Honor.
Okay. This 744. Is there an article in the contract law of the DIFC which adopts the same language of 744 Unidroit?
The counsel seeks a minute, Your Honor.
Okay, if you need time, that's okay. You might address this in rebuttal. Don't worry. I'm happy at least I think you got my point now. You have time. You have time later to check this point. You can carry on with the argument.
Sure, Your Honor. Further, Your Honor, the concept of foreseeability contained in the principle allows compensation even for harm which is unforeseeable when the non-performance is due to willful misconduct and gross negligence. Hence, Your Honor, in the instant case, the Solar Dream was able to foresee the non-performance of the space mission in the wake of Vulcan variant of COVID-19. But however, it continued with the mission without due care, which led to Artemis, including the other passengers, getting infected with the Vulcan virus and eventually aborting the space mission due to their gross negligence. Hence, the Solar Dream in this case is liable to negligence under Article 17 of DIFC Law of Obligations. Your Honor, moving to the second part of my arguments, that is liability of Solar Dream in contract. Firstly, Your Honor, the Solar Dream has failed to discharge obligations in light of the force majeure clause. Your Honor, a force majeure clause is engaged by the occurrence of a specific event or events which can occur with or without the human intervention. It submitted that clause 1.1 of the spaceflight contract provides a time period of 9 days, that is from 14th February to 23rd February, to launch the space mission. This launch window was contingent on various factors, but not limited to meteorological conditions, technical readiness of the spacecraft, and regulatory approvals. Further, Your Honor, Article 82 of DIFC contract law provides the party to invoke force majeure in extraordinary events and circumstances. But, however, there are two requirements in order for an event to constitute force majeure. Firstly, the event cannot have reasonably been foreseen by the parties, and secondly, the event was completely beyond the parties' control and they could have not prevented the consequences.
Sorry, Councillor Tanaka, but can you remind me, why are you discussing force majeure here? I mean, in my mind, force majeure is a defense. Is a defense to somebody's claim. Here you are making your submissions regarding your client's claim. Why are we discussing the defense?
Your Honor, here the point I'm seeking to make is the defendant cannot take the remedy under the force majeure clause, as that has not been mentioned in the contract. That's the point I'm seeking to make, Your Honor.
Is this in the record? Is force majeure in the record?
Sorry, Your Honor?
In the Moot problem, is there any point in the Moot problem where force majeure is mentioned?
No, Your Honor, but the COVID-19 situation can be taken as a special circumstance which could constitute a force majeure.
So you expect that the defendant might make an argument of force majeure, and you are laying down your objection to that potential argument.
Your Honor, generally in common law principles, the force majeure clause is not generally accepted. But whether in DIFs, only if it expressly made, the common law allows it. But however, in DIF, the law under DIFC allows a force majeure clause even if it's made impliedly. With regard to that, coming to the space flight agreement.
Okay, Council, sorry to interrupt again. I think I heard about force majeure. We'll see if the defendant intends to make any arguments about that. You have the opportunity to address this in rebuttal. I'd like to hear a little bit about the substance of your claim. So we discussed liability of the defendant. We discussed why you submit the defendant is liable and why they breached the contract. What I'd like to hear from you is also what damages arise for your client, what damages your client has suffered, and why those damages are causally connected to the events in question. You have 4.5 minutes, so I encourage you to address these points.
Indeed, Your Honor. Proceeding this, the Solar Dream unreasonably expedited the launch date despite the alarming situation. It is submitted that Wilton variant of COVID-19 spread easily and it was symptomatic within 5 to 10 days of being in contact with the carriers of virus. In wake of this event, the passengers were given a cursory medical examination by nurse by conducting lateral flow test and PCR test. The defendant considered the results of only lateral flow test and completely neglected the PCR test due to the delay.
Sorry to interrupt again. This we know, this relates to the conduct. As I said, you already discussed the conduct. I'm satisfied about your discussion of the conduct. Can you tell me what are your client's claims? What does your client want? What is the remedy your client is seeking from this court?
Your Honor, according to paragraph 14 of the Moot proposition, the prayer of my client is to seek a damage of $15 million by way of refund and damages for what she says is failure of Solar Dream to provide the services that she paid for, because of the negligent acts undertaken by the Solar.
But your client paid 10 million, right? Not 15.
Your Honor?
how the cost of the ticket was 10 million, right?
Cause of, sorry, Your Honor, I'm
The
unable to
ticket.
hear.
So sorry, do you not hear me well? Is my microphone not working?
Now I'm able to hear it.
Um, the the cost of the ticket was 10 million, right?
Yes, Your Honor, yes.
Right? Why your client is claiming 15 million?
Your Honor, that is because it has also caused her damages in the has caused loss of her earnings through the YouTube channel, because she had publicly advertised that she'll be going to the space mission, and also made a lot of promotions and advertisements in that regard. Due to but because of non-performing or non-fulfilling that promise, there were a substantial reduction in their subscribers or viewers list, and in order to compensate that damages, claimant is demanding $15 million.
Mm-hmm. So 10 million will be, I suppose, the cost of the ticket, and 5 million are the what is the breakdown of damages? So your client essentially have two claims, right? One claim for direct losses, the cost of the ticket, 10 million, and the remainder 5 million are lost profits.
Yes, Your Honor, for the loss of her reputation in the
Okay.
public.
Yeah, under DFC law, where in the DFC law, or I mean the DFC law of damages and remedies, what is the legal source of the right to claim for loss of profits?
Uh, can I just get a minute, Your Honor?
Yeah, okay, you have time to research this. I just have, since you have less than a minute, just one question. So in the record, we know that the contract included a clause limiting damages to 1 million.
Your Honor, Miss Atrocia seeks $7.5 million by way of refund of the sums she paid for the ticket, and $7.5 million in damages for the non-full,
Yeah, these I
because she was
know.
unable.
Okay, if you go to page 14 of the Moot problem, which is clause 4.5 of the contract, it says, in all circumstances, the space flight operator's total liability for any and all claims shall be limited to a maximum of USD 1 million.
But Your Honor, in this instant case, the company has not fulfilled the obligations or the contract it had undertaken, and additionally, it has also my client has suffered damages because she was unable to film the yoga videos.
This I know. As I said, I'm satisfied with your submission that your client that side has breached. Oh, whether we will hear the response, but you addressed this point. You discussed this abundantly. I don't want to hear any more of that. I want to hear from you if this court were to determine the defendant breached the contract. Why should this court award 15 million and not 1 million, since there is a clause limiting, capping liability to 1 million?
Your Honor, this exclusive and limited liability clause cannot be applied in this instant case. I'll be submitting on that. In the case, in support of the same, I'll be quoting a case. In the case of D Bears UK Limited versus Atos Origin IT Services, the judge stated that limitation of liability costs contained in the contract was not to apply while when there was willful misconduct by a person who knows that he is committing and intends to commit a breach of duty, or is reckless in a sense of not caring whether or not he commits a breach of duty. Thus, Your Honor, in assessing the amount of damages to be awarded, the judge refused to consider the limitations and exclusions of liability clause.
So in this case, which one is it? What happened here? What is the factual circumstance here? Referring to the facts, what is the fact here that allows you to disregard the clause on the basis of that precedent.
Your Honor, in this case, De Beers was engaged in a diamond business, and it seeked to expand its business.
No, talk about the conduct. The clause says the liability is 1 million unless there is gross negligence or willful misconduct.
Yes, Your Honor.
Okay, so you need to tell me why there is here. First of all, do you think there's willful misconduct or gross negligence?
There has been both, Your Honor, the gross negligence and willful misconduct on part of Solar Dream. And because of that circumstance, they cannot take the remedy under limitations and
I want to know
exclusions.
why. What exactly represents gross negligence here? What is the gross negligence?
Gross negligence is wherein they have committed negligence in a large aspect, Your Lordship. It is not limited to a particular instance, but it has been carried out in the course of their space mission.
All
If
right.
Your Lordship.
Okay, I'm sorry, but we went already considerable of time, and of course I will have more time to the defendant. Would you like to wrap up your argument?
Indeed, Your Lordship. Your Lordship, when it comes to compliance with the certain clauses in the agreement, the Solar Dream has gravely violated this, and it has not fulfilled the safety protocols given under the clauses, and hence it has caused gross negligence and willful misconduct in carrying out the same.
All right, thank you.
Thank you, Honor.
Okay, now I think we will hear from Ms. Zaidi, correct? For the defendant.
Yes, you're
ready.
okay. So I shall start. Your Honor, I shall be addressing the first ground of defense in which Solar Dream Incorporated is not liable towards tort and breach of contract, as the defendant took sufficient duty of care and it did not violate any clauses specified in the space flight agreement contract, and it should not be held liable for non-performance, in which I'll be expanding on these details shortly. Subsequently, my junior co-counsel will be addressing the second ground of defense and a counterclaim in which Ms. Estrothia has liability to Solar Dream for breach of contract, as Ms. Estrothia owed to the defendant fiduciary and contractual duty and was bound to act in good faith, which my junior counsel will also elaborate on shortly. So in light of all of this, Your Honor, I will proceed with my submissions. So in regards to my first ground of defense, I have two submissions to make. The first submission is regarding liability towards tort. So Article 17, DIFC, Law of Obligation, number 5 of 2005, states that a defendant is liable in negligence to a claimant if and to the extent the defendant breaches his duty of care to the claimant. However, in this case, this is even specified in the case of Donahue versus Stevenson, where it has said that a duty of care is a legal requirement imposed on an organization that requires adherence to a reasonable care standard while preventing any activities that could reasonably be expected to harm others. So in this case, the defendant took proper care in ensuring that the space flight expedition will be conducted without any complications or without any hindrances. Both the parties signed a space flight agreement. They were asked to provide a declaration and while signing the agreement, they were asked to provide a declaration stating that they don't have any health issues or health problems. And they even conducted another examination of PCR tests and lateral flow tests to determine any signs or symptoms of the Vulcan virus that was spreading preceding those months. All this while, Artemis made no mention of her headaches that she was suffering from the past 5 years. This was even stated in the contract clause 4.4, I believe, where they were supposed to disclose all of their medical conditions. And in this case, the claimant did not mention the fact that she was suffering from chronic headaches for the past 5 years. And even while signing the contract, the agreement, they were told that in the case of unforeseen events, like in this case, the spread of the Vulcan virus, and the risks will be unavoidable, and that the passengers must accept the possibility of these unforeseen events. So, despite these unforeseen, foreseeable circumstances, the defendant still somehow managed to practice their duty of care by ensuring that medical examinations were regularly conducted, by ensuring that PCR tests were taken, lateral flow tests were taken, so that all of the passengers were were safe, and that they would be on the space flight expedition. This
Sorry, Council, if I interrupt you here. Yes, we do know that a rapid test was undertaken and the results were negative. However, we also know that there was a wave and a new wave of pandemic near the events in question, the COVID pandemic near the events in question, and it's I think undiscussed that the only way to ascertain whether or not somebody is infected is a PCR test, which these days can be obtained in a few hours. And we also discussed with your learned friend that your client should be subject to a heightened standard of duty of care of professionals, not of normal people. So, what do you have to say in respect to your client complying with its special standard of care, but neglecting to hold the flight before receiving the PCR results?
Regarding this, it is to be made sure that when it came to the lateral flow test results, those were results that were said to be sufficient enough by a healthcare professional, by a nurse, who said that these results would be sufficient. However, because Artemis, because the claimant did not specify that she had been suffering from chronic headaches for the past 5 years, which were very severe in nature. She did not specify to any healthcare professional. She did not mention it to the company, which is why the PCR test probably were detected it as were not able, which is why the lateral flow tests were not able to detect that symptom, but the PCR tests were able to do that. However, if
Yeah, sorry, Council. That's factual scientific explanation, which probably should be better addressed by a technical expert. But I think the point I'm interested in now is a legal point. So what a claimant has or has not disclosed might be relevant, I think, under different legal grounds. But I'm interested to hear from you in the first place. Has your client complied with its special duty of care by neglecting the PCR test?
I think my client
You
did.
think, or you submit your? Remember, you represent your client. You don't think. You
Sorry.
make submissions.
I would say that the client did take special standard duty of care because, as the nurse said, that there was that it was sufficient enough to do so, and the space flight. Regarding that, there was a lot of money that was invested into the flight. So holding off the flight or maybe delaying it a little longer would have caused even further damage. Therefore, it was probably safe on their side to take off the flight a little earlier. And it was specified that the lateral flow tests were sufficient. Therefore, the flight was able to take off.
Okay,
And
go ahead,
yes.
please.
Okay. Then I would say that Article 18, Clause B, Law of Obligations, number 6 of 2005, states that to prove prove the existence of duty of care, there must be a relationship between the defendant and the claimant. So in this case also, the parties had a contractual obligation as they signed the space flight agreement. And yes, that's all. I think moving on to
Sorry.
my
What is your point that you want to make here? Are you saying that there is no relationship?
that there is a relationship, because I proved according to Article 17 that there was
Okay, but
that
how does that support your client position?
that to prove that both of the parties had that the defendant had a certain duty of care because
Yeah,
they signed the space flight
but that's your
agreement.
client.
Yes.
So you say you agree with me that your client had a duty of care. So there is no defense.
No, they took duty. What I It's just further proving my point, submission actually, that this that uh, this is it's kind of a proof that there is an existence of a duty of care.
Okay, but I understand that. And I think in that you're in agreement with the claimant. The claimant says that your client had a duty of care and that duty of care was breached. So I understand that you do not object to the assertion. You agree that your client had a duty of care. You don't object to that. Um, can you tell me why do you say that duty of care was not breached then?
We say it's not breached because, as the facts mentioned, we took we conducted tests. Our client conducted tests, conducted medical examinations, ensured that everyone was safe before they proceeded towards the flight. Therefore, my client did practice their duty of care.
Okay, so your submission is that the first test was sufficient to satisfy their duty of care.
Uh, yes.
Okay, carry on.
Okay, so moving on to my second submission, which is regarding liability towards breach of contract. So under Article 109 in the DIFC contract law number 6 of 2004, it states that non-performance of the party gives right to, just a second, yes. Uh, yes, Article 109, right to damages, states that any non-performance gives the aggrieved party a right to damages either exclusively or in conjunction with any other remedies, except where the non-performance is excused under this law. So in this case, the defendant did not breach any terms in the space flight agreement, and even in clause 4.5 of this space flight agreement, it is stated that all claims shall be limited to 1 million US dollars, whereas the defendant exceeded that limit, seeking damages of seeking damages of 15 million. And clause 5.2, it is stated that passengers were required that they had to disclose any of their medical conditions, of whichever of their medical conditions that they're aware of, and uh, and that this flight would have like yeah, that the flight would result sorry yeah, again, clause 5.2, it is stated that they were required to disclose all of their medical conditions, in which Artemis failed to do so. And the claimant since the claimant did not disclose her medical condition and she went beyond the amount stated in the contract for suing for damages, we believe that she did not perform she herself breached the contract, and she did not perform her duty to do so. And to
Sorry. Does the claimant has the right to negotiate with your client in this term?
they both of the parties signed the contract, so if there was room for negotiation, they must have discussed it beforehand before they signed the contract.
Okay, thank you.
Yeah. So, and then moving on, Article 103, number 6 of
Sorry, Cassio, to interrupt here. Just I'm a bit lost in your argument. what point are you making here? So we discussed the standard of conduct that is applicable. You told me why you think this was not breached, and now what point are you making? Are you you mentioned the failure to disclose the condition by the claimant. How is this relevant in relation to your defense? What point are you making here?
That they breached, that the claimant, Artemis, had breached the contract by not failing to, they're not failing to disclose it. Themselves, the claimant themselves breached the contract in this case. That is the point.
Okay, so you're saying that, but are you saying even if this court rules that your client breached its standard of duty, breached the contract before, also the claimant breached the contract? That's what you're saying?
No, they breached the clauses of the contract.
And so what? What is the consequence of this?
Yeah, we think that because she breached the contract, that she actually must be held liable for breach of contract, which is further
Okay, but I think I will hear about this from your colleague in relation to the counterclaim, right?
Yes.
So if the claimant breached the contract and whether or not that entitles your client to seek compensation, that will be relevant for the counterclaim. But here we are discussing your client's defense to the claimant's claim.
Right.
Right?
Right.
So, okay, since you have, you usually said you have 16 minutes, you have or about 1 minute. I will give you 2 minutes since also the discussion took a bit longer. But I'd like for you to focus a little bit on the damage. So we discussed the conduct. So you're explaining why you say that your client did not breach its duties, and you explaining why you think the defendant, the claimant also breached the contract. Can you tell me a little bit about and also you discussed the clause capping liability at 1 million. The claimant said that the clause might not be applicable in the circumstances. So if this court were to rule and the clause is not be applicable, and therefore it's not a defense, and claims for the full 15 million, what other defense you have in terms of quantum? So if this court were to rule that your client is liable in principle, what do you have to say about the quantum, or how much is your client liable and why?
I think our client is liable for they sued for, I think, for 5. Just a second. Yeah, they seek a counterclaim seeking for 5 million
No,
US.
no, 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 no. I'm talking about the claimant's claim, 15 million. I'm talking about that.
About that,
Okay, and so the claimant is claiming for the 10 million of the ticket that she paid. And since the trip was not completed, the claimant's claim that there is no trip, I paid 10 million for nothing, give my money back. And the claimant is also saying, there were potential profits that I could have gained if I had done a video, if I had some video, some story on my social media regarding the trip. So what do you have to say about that?
we believe that I believe that the defendant is
You
not.
submit. You don't believe. You submit.
I submit that the defendant is not liable to pay the claimant 15 million US dollars for damages because because one is that because she was not able to disclose her health conditions, and because because of her the PCR test was positive, which infected other passengers in the flight also, and due to that the trip
No,
was.
no, 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 no. Sorry, that's again about liability. I'm asking about the nature of it. Okay, so the first claim is a claim for direct damage, right? The cost of the trip. if your client were to be liable, I don't think has a strong defense to that. But regarding the loss of profits, what is your defense in relation to the claim for loss of profits? So, what is your can the claimant claim loss of profits? Is the claimant allowed to do that under the contract under the DIFC law?
No, the claimant is not allowed to do that.
Why?
Because according to Article 113, they did not perform they are non-performing party, and because they were not able to disclose, because the claimant was not able to disclose her medical condition, we believe, I submit that that the claimant cannot be held, cannot sue for $15 million for damages, as she is
Okay.
a non-performing
Thank
party.
you. Thank you. I think that's enough on this point. Would you like to conclude your submission?
Yes. So, Your Honor, that concludes my second round of submissions. It was a pleasure arguing in this court. If I may be of no further assistance, I would like to refer this court to my junior co-counsel.
Thank you. I think before that we have rebuttal
Yes, Your Honor.
from Miss Kurtikay. Please.
Your Honor, first I would like to address a few uh, the queries that were addressed in the submissions. Firstly, the foreseeability, the Article 7.4.4, which talks about the of Unitroid principles, which talks about the foreseeability, has been incorporated in DIFC contract law under Article 113, which reads as the non-performing party is liable only for harm which is foreseen or could reasonably have foreseen at the time of conclusion of the contract as being likely to result from its non-performance. So, Your Honor, the given the circumstances of spike in Vulcan variant, it was very much evident that the Solar Dream could have foreseen the repercussions, could have understood the gravity of the situation and foreseen the repercussions of the non-performance of the contract. And further, Your Honor, coming to the damages that my client is claiming, that is $15 million. Your Lordship, firstly, my client had paid $7.5 million towards the ticket, and another $2.5 million she was supposed to pay after the fulfillment of the contract or after the space yoga retreat. Further, Your Honor, this $15 million and the remaining $7.5 million is based on the torts committed by the Solar Dream. Your Honor, in the contract law, yes, according to the terms of the contract, the cap is mentioned as $1 million. But however, there is no cap mentioned in the case of commission of a tort on the part of the defendant. So here, based on this rationale, my client is claiming for $7.5 million for the torts committed by the defendant. Further, Your Honor, coming to the submissions made by the senior defendant, here the company cannot just blame Artemis for the non-disclosure of the medical conditions or for any other aspect and get away or get rid of its own liability when it has been evident from the many instances that the company itself has breached the contract or has failed to take the reasonable standard of care. Uh, further, Your Honor, the company Solar Dream has vaguely relied on the mere advice given by the nurse as to the accuracy of the lateral flow test without even examining as to its authenticity and the reliability, especially in the extraordinary situations as the spike in Vulcan variant of COVID-19. Further, it has unreasonably proceeded with the mission by only considering the meteorological conditions and completely neglecting the repercussions that it would have on the health of the passengers, and has thus violated clause 1.1 and 1.2 of the agreement, space flight agreement. Therefore, Your Honor, with respect to the claim, the council submits that Solar Dream has violated the reasonable standard of care and caused significant harm to the claimant. Further, it has largely breached the contract by ignoring the extraordinary circumstances by taking unreasonable steps leading to the violation of the safety protocols under the agreement. With this, I would like to submit my rebuttals, Your Honor.
Thank you. Rebuttal, Ms. Zaidi.
Yes, Your Honor, I would like to state that the Solar Dream, my client, provided sufficient duty of care because medical examinations were conducted for the safety of the passengers regarding their medical condition, regarding their fitness and their health, to ensure that they are physically fit and appropriate to travel on the space flight, and that therefore by not stating their medical conditions or not disclosing their medical conditions, they put the company and other passengers of the flight at risk. And even with the spread of the Vulcan virus, lateral and PCR tests were done, and it was said to be sufficient enough. And the space flight itself costs around millions of dollars, which is a big investment for the company, and postponing it would have led to further damage to other, not just to the company, but to the other passengers themselves. And even
Sorry, counsel. So are you pleading necessity? Are you saying that your client had no choice but to board that flight?
I
Or
am
are you pleading mitigation? So are you pleading that had your client canceled that flight, damages would have been even higher?
Yes, I am mitigating that if the flight was cancelled, the damages would have been even higher.
All right, thank you.
And therefore,
That's all?
uh, yes, lateral, yes, that's all, Your Honor.
All right, thank you. Okay, so I believe now we will hear from the Mitaj.
Yes, Your Honor, the Amiraj.
Okay, regarding the contract claim, correct?
Your Lordship, could you repeat that? I could not hear you.
You will discuss your client club counterclaim.
Yes, Your Honor.
Okay, you can start when you're ready.
Good day, members of the bench. I am Dia Miraj, appearing as the junior counsel on behalf of the defendant in the case Artemis Astrothea versus Solar Dream, and I shall address the counterclaim in this instant case, which is Miss Astrothea's liability towards Solar Dream for the breach of contract. Your Honor, Artemis Astrothea, the claimant, had entered into a contract with Solar Dream, the defendant, to go to a space yoga retreat, but only for it to end prematurely, as Miss Astrothea failed to declare her medical condition, which would have caused significant harm to others in this retreat. Solar Dream, being an honest and trustable organization, had to prioritize their clients' health and safety over their profits, and therefore had to return back to Earth. Solar Dream today files a counterclaim against Ms. Astrothea for the damages caused to the company and their clients. Firstly, for not confessing her medical conditions, thereby ceasing the retreat. Secondly, incriminating the company on her YouTube channel. And lastly, for the significant reputational loss which led to multiple passengers cancelling their reservations for future retreats. With these in mind, the Council would like to begin its arguments on the second ground. There are two submissions to this argument. The first one is that there existed a contractual and a fiduciary duty from the claimant towards Solar Dream. And the second submission is the existence of a duty to act in good faith. If it may please this Honorable Court, the Council would like to begin with the first submission. Your Honor, may I
Sorry. Does the DIFC rules include the good faith principle?
Yes, Your Honor, it does include the good faith. I will be addressing it in my second submission.
Okay, thank you.
To begin with my first submission, Article 40 of the DIFC contract law talks about fraud and how non-disclosure of material facts leads to violation of a contract. In the present scenario, Ms. Astrothia intentionally hid material facts which could not have been known by the respondent. But it was, she was under the knowledge that concealing those facts would cause serious damage to Solar Dream. Article 3.8 of the Unidroit principle says that fraud, like mistake, can involve either representations, whether they're expressed or implied, and even false facts and non-disclosure of true facts. I would like to cite the case of Horsfall versus Thomas, where the court held that active concealment was recognized as a
Sorry,
fraudulent.
this case is from what court?
Just give me a moment, Your Honor. Horsfall versus Thomas is a court of exchequer, England and Wales.
And is this case binding in a DIFC?
Yes, Your Honor. This case is binding because it is from a common law jurisdiction.
Is the DIFC part of the Commonwealth?
DIFC follows principle of the common law as it has got persuasive value.
So is it binding or persuasive?
The DIFC, in fact, follows common law jurisdiction. Yes, it is binding, therefore.
But what is the difference between binding authority and persuasive authority?
A binding authority is when the court is meant to follow a decision from a superior court, but a persuasive value is when it is from another jurisdiction. But in the instant case, it is from a binding jurisdiction, which is a common law jurisdiction.
No, that's not right. That's not right. Sorry, the DIFC is not part of the Commonwealth. Is part of sovereign country. English precedents are sometimes persuasive, sometimes are very persuasive, but they're not binding. This is a sovereign country. The Queen has no authority here.
Yes, Your Honor, I understand that. So I apologize for the same as well.
Okay.
Further, in the case of Lawning versus Dimwater Homes, excuse me, Your Lordship. Further, in the case of Longing versus Dimwater Homes, it was required for the plaintiff to prove 5 elements which shows misrepresentation. And this is also similar to a DIFC case called Gulf Petrochem Free Zone versus PetroChina International, where the court said that misrepresentation by concealment requires the plaintiff to prove 4 elements. The first element is that the defendant had concealed or misrepresented a material fact. The claimant, despite suffering headaches for the past 5 years, had failed to disclose this information at various stages. Firstly, in the disclosure form, subsequently to the specialist doctor from Solar Dream, and finally in the morning of the flight to the nurse when she had taken their PCR and lateral flow test. This satisfies the first element that the defendant concealed or misrepresented a material fact.
So, sorry, where is the test in the law? You refer to the article.
Lordship, would you refer to page number 72 of the Moot Court bundle?
Okay, but I'm interested in the article. What article of DFC law? What law and what article provides the test?
Article 40 provides for the fraud, but there isn't a provision that explicitly...
Article 40 of?
Provides about fraud.
40 of what law?
40 of the DFC contract law.
Contract law, okay.
Yes.
Yes.
It provides fraud.
Fraud is a party may avoid a contract when it has been led to conclude the contract by other party fraudulent representation. So this is a defense.
Yes.
What this says is that you enter in a contract and it comes up that you enter in the contract because somebody lied to you, but then entitles you to get away from this contract. This is a defense. It's not a claim. So this cannot be the basis for your claim.
Your Honor, the basis for my claim is that there exists a contractual and fiduciary duty which Ms. Astrothia had violated.
This I know, but And you're saying basically that the claimant lied to you, right? She lied.
Yes, Your Honor.
Okay. Assuming that you can raise a claim because somebody lied, a civil claim for damages, what part of the law of the DIFC establishes a right of action
Right of.
because somebody lies?
Yes, Your Honor. It is there is section 77 of DFC contract law, which talks about non-performance of a
No, that's
contract.
not performance. Okay. Is there anything in the law of obligations?
The law of obligations, I believe, was for tortious liability.
Yes.
In
And
this
is
instant
it
matter, under a contract violation, when Article 40 is read with Article 77 and 109 of the DFC contract law, non-performance, which is failure for a party to perform an obligation, gives the aggrieved party the right to claim damages.
so you're not pleading misrepresentation? This is not your claim. You're
Pardon?
not pleading. You're not pleading misrepresentation.
We
This is
are
not.
pleading. We are
You are.
pleading fraud through active concealment.
Okay. And is that a form of misrepresentation?
Fraud is different from misrepresentation, but there are strings of it which can intertwine to give it a similar
I'm
outlook.
interested in, is misrepresentation part of your case? Yes or not?
Misrepresentation is a part of our case.
Okay.
I'm
And
citing
where?
the elements of misrepresentation.
Okay. And where the test for misrepresentation? Where is this test in the law?
This test is cited in a DFC contract case.
No, in the law, in the statute. Is there any statute here that talks about misrepresentation?
Apologies, Your Honor, I'm not able to cite a provision regarding the same. I can only give
Okay,
you.
I will tell you. It's Article 29 of the Law of Obligations.
Yes, Your Honor.
Okay, you might address this in rebuttal, but carry on with your argument.
Yes, Your Honor. So, moving on to the third element, which is that the defendant intentionally concealed or suppressed a material fact. The plaintiff was aware that exposing her medical condition would have had her journey to be called off, which is clearly stated under Article 5.4 of the Space Flight Agreement, and therefore she would have suffered monetary loss. Now, with respect to the fourth element, that is, the plaintiff was not aware of the fact, and if the plaintiff was a plaintiff in the instant case, the defendant, if the defendant was aware of the fact that she concealed a material fact, the defendant would have acted differently. Well, it is clear that Solar Dream had implemented various safety measures to guarantee that nothing out of the ordinary would take place while they were traveling. Well, this is evident from the numerous measures they had taken to guarantee the same, like having a traveler's medical assessment done, having them to quarantine 2 weeks prior to the excursion, and even offering pre-departure accommodation. So therefore, it is clear that Solar Dream wanted to complete this assignment in the safest way possible. And only if Miss Astrothea had just informed them about her illness, they would have taken care of the same. I would also like to cite the case of Caparo Industries versus Dickman, where the court held that the defendant, when they're providing advice or information, if they was fully aware that the plaintiff would rely on it, then it is on the plaintiff. Now, regarding the fifth element, which states that the plaintiff must have suffered damages, well, as a result of concealment or suppression of material facts, because of this, the claimant violated the terms of the contract. The respondent suffered significant damages as a result of having to terminate this journey early. To further reiterate my argument, I would like to cite the case of Shields versus Blackburn, where the court held that If a man gratuitously undertakes to do a thing to the best of his skill where it is required in a situation, then the omission to do that amounts to fraud. And also,
Counsel, sorry, since you have 4 minutes left, I'd like to hear from you because I haven't heard much about that, about the damages that your client has suffered. So you told me why the claimant defrauded your client, what the claimant did wrong, why the conduct, why the actions of the claimant were wrong. We understand that, but you didn't tell me much about why, in consequences of this action, your client suffered losses. Understand your client is claiming 5 million. What is the breakdown of this 5 million? Where these 5 million are coming from?
yes, Your Honor. So the counterclaim is filed for $5 million, and the basis for this claim or the reason for the damages is that. Just give me a moment, Your Honor. The first reason is that Miss Astrothea did not confess her medical illness. And because of this, the retreat had to end early. This is the first reason for us suing for damages. The second reason is that she incriminated the company on her YouTube channel various times.
Hold on. On the first one, because of her action, the trip was cancelled.
Yes,
so
sir.
what are the damages in terms of bottom line money? How this affected the company?
Yes, Your Honor. The rest of the passengers in this retreat had paid for a 10-day journey, but it had to end prematurely. And because of this, our company is responsible towards other passengers as well. We told them that we had told them that they would be that they would have a 10-day trip, but then it was cut short, and this will cause monetary loss and will affect the reputation and goodwill of the company.
So what monetary loss? Are they asking for refund of the tickets?
It's not expressed. The facts are silent on whether the other passengers are claiming for refund, but there is an effect of goodwill, and uh, and as and as a reputable organization, it is Solar Dreams. It is Solar Dreams' duty to provide the other passengers with some kind of compensation for what they have gone through because of Miss Astrothea's negligence.
Okay, so compensation to the passengers. Okay. Go to the second one.
The second one is that.
Sorry. Do you think this is direct harm for the company, for your company?
Yes, it's definitely a direct harm, Your Honor, because firstly, mainly because of the second reason, which I'm about to say, that is by incriminating the company on her YouTube channel, it affected the reputation and the goodwill of our company. And because of this, many other future reservations have been cancelled, and therefore directly affects our company.
Okay. Thank you.
So, Your Honor, so the second reason, as I said, is that it affects the reputation and the goodwill. And the third reason is that because of this, it led to multiple passengers canceling their reservations for future space retreats. And this also causes monetary loss for our company. Your Honor, may I move to the second submission?
Yes.
Moving on to the second submission, which is the existence of a duty to act in good faith. So there exists an idea that the parties to a contract owe to one another a duty of good faith in carrying out their commitments. This is supported by Article 1.7 of the Unidroit Principle, which is in page number 35 of the Code Bundle. It highlights the importance of good faith and fair dealing as one of the fundamental principles in contract. There's also Article 56 of the DIFC contract law, which states that duty of good faith exists in a contract law, whether it's implied or expressed. It exists no matter what. I would like to quote the landmark.
Sorry, Counsel.
Yes,
Interrupting 2 reasons. One, you're out of time, so we'll have to ask you to conclude in 30 seconds. And second, can you be focused on the claim itself, like this loss of reputation.
Yes, Your Honor.
Why? What is the legal ground? So, what article of DIFC law allows you to claim for loss of reputation?
Your Honor, it's because of Article 77, that was non-compliance or
That's breach of
non-performance.
contract. That's no. It's the answer is in the law of obligations.
Your Honor, the council was under the idea that law of obligations was for tortious liability and not for contract. Therefore, was referred by my senior counsel.
Oh, okay. Well, you might address it in the rebuttal.
Yes, Your Honor.
I will. I'll give you 30 seconds to wrap up your argument.
Your Lordship, I have an important case, which is a DIFC case, that is Union Insurance versus International Precious Metal Refinery. In this case, there was a refinery, the claimant, they took out an insurance policy with the defendant to cover any risk of damage or any risk of loss or damages to the gold in the said location. But then, unfortunately, an accident occurred where a water tank fell on the gold, and it caused the gold to run and mix with the sludge and slurry from the floor. This resulted in a big amount of.
I need to ask you to wrap up because it's already.
Yes, Your Honor. This case has a greater binding value. That's why I'm emphasizing on it. So, in the end, the court ruled in favor of the insurance company because the insurance company, in its defense, stated that the refinery misled and omitted to disclose the correct volume of the gold. And with that, I would like to conclude my argument by stating that for the reasons mentioned above, the council would like to state and reinstate that the Solar Dream has complied, that Ms. Astrothea has violated the terms of the contract by suppressing material facts, which resulted in significant monetary loss for the respondent. Therefore, the counsel for the respondent pleads the court to quash the claim and rule the counterclaim in favor of Solar Dream and award 5 million as damages.
Okay, thank you, counsel. I will have to take 1 minute of your rebuttal.
Yes,
so it'll be 4 minutes, not 5.
Yes.
And with that, thank you for your submission, and I'll give the word to Miss Miss Jane.
Manisha Jain.
Yeah.
Yes, Your Honor. Good afternoon, good evening, Your Honors. The counsel I'm Manisha Jain, on behalf of the claimant. I would seek your permission to move ahead with the issue 2. Your
Please.
Honor, the issue 2 deals with the Miss Artemis liability to Solid Dream for breach of contract. For it is humbly submitted before this honorable court that Miss Artemis does not own any liability to the company for the breach of contract. For the convenience of the court, I would submit this this argument in three folds. Firstly, Your Honor, Miss Artemis has the benefit of equitable consideration and relief. Your Honor, both equitable consideration and relief, often called as a clean hand principle, applied when a party has acted in a good faith. Your Honor, according to Article 57 of DIFC contract law, and which is incorporated from 1.7 of Unidroit principle, the parties are required to act in good faith, and fair dealing. Now, I would seek your attention.
Stop you there. Thank you for quoting the Unidroit principles, which are persuasive authority on this court, given the source of the contract law. Can you tell me where in the DIFC contract law this principle is recognized?
Your Honor, the Article 57 and 58 of DIFC law, which talks about that, the parties to the contract are believed to act in a good faith and fair dealing in international deals. Your Honor, I would seek your attention to 5.2 clause of the agreement of the Moot proposition. It states that the passengers declares and represent to the best of their knowledge and belief that they are not aware of any medical conditions or symptoms of potential medical condition. Your Honor, the space flight agreement required passengers to declare those potential medical conditions. Now, here, Miss Artemis did not reasonably believe and foresee her headaches would impact her fitness for the travel, supported by her fitness in past 5 years by dealing with the same common headaches without being any interruption in her day-to-day life, and extensively history of managing same these headaches without interfering with her professional activities also. Your Honor, further it is further I submit that the headaches were not symptoms of the Vulcan variant provided in the list, like fever, chills, sore throat, sore eyes, etc. She had common headaches since from past 5 years. Your Honor, further when the lateral test results came, I would like to bring your attention to the para number 6, that she waited to get back the results, but there was a delay at the lab. Your Honor, she with the utmost honesty waited for the results, but again it was the negligence of the company to take a green signal. Now, therefore, when the when the lateral flow results came negative, she ruled out she ruled out any possibility of contracting the Vulcan variant, and she firmly believed that she did not have the new COVID. Therefore, Your Honor, as I would submit a very important case, that is Unwin versus Bond. This is a
Sorry,
case.
what court is this case?
Your Worship, in this case, it acts about the good faith and it sets out minimal standard points. Sir.
No,
So
no,
the
no.
court,
What you're quoting a case, right? You're quoting
yes,
a
sir,
judgment.
yes. I'm quoting a case with a judgment.
Okay, from what jurisdiction?
It is a common law case, Your Lordship.
It is, sorry,
So
what?
it is a common law case.
Yeah, from what jurisdiction? What country?
It is English law court.
From England and Wales. Is
From
England and Wales.
Yes, Your Lordship.
What court? High court, county court?
The High Court, the Honorable High Judge Court of this, they laid a minimum standards in which there is the core requirement of good faith.
Is there any case there is no case in the DFC about this?
Your Lordship, the good faith case, which is going to support my argument, is more relevant in this case. It is a minimum. It is a minimum standard points which has given by a court. So the case talks about utmost honesty, Your Honor. The core element of good faith is honesty. Now, Your Honor, I would submit that regarding the note.
Sorry, can you do a summary for me of this case? What
This
that case?
This case is there are two shareholders in this case, and there was a breach of contract. But the court gave a release to the claimant because of they acted in a good faith, and the core element was the honesty. That the core requirement of the good faith is honesty, innocency. Therefore, when we look at these facts, Your Honor, in this case, with regarding non-disclosure, as we all know, Artemis is a very highly influential YouTuber. Plus, with her professional yoga experience of past from 6 years of her age, she firmly believed that her headaches. She has been carrying these headaches from a very long time, and she's been doing in her day-to-day life without any hindrance. Now, when she went to the doctor, she could not find any cure to the headaches. And as a professional expertise, she believed that the Earth's gravitational force is not helping her in finding that cure. So later, she firmly believed that the company also provided the theme of the mission was a celestial energy. So she believed that the celestial energy in the space would find a cure to her headaches. Now here the entire facts represents her honesty. Therefore, the Artemis did not have any intention to deceive the company or to bring any do any fraud or do any harm to the company. Therefore, it is submitted that the non-disclosure of the headaches did not result in the direct harm or impact of the safety of the flight. Further, Your Lordship, secondly, no direct causation and no liability arises for reputational damage. Your Lordship, the company is seeking dollar USD 5 million USD for the reputational damage. She's not liable to play, Your Honor, because firstly, the flight for the mission took the green signal without the PCR result, assuming that all the lateral flow tests were statistically right. Secondly, and very importantly, that the green light was purely based on the advice of the nurse on a duty and not by the eligible doctors on the duty. Your Honor, I would seek your attention to the agreement clause 7, space flight operator safety protocols. In this agreement of 7.2, subclause B, part 7, 8, and 12 of the Space Industry Regulation. The part 7 of Space Industry Regulation 2021 reads that, chapter 5 reads that medical fitness states certificate and confirmation of the medical fitness by the eligible doctors. Here, purely on the advice of a nurse on a duty, they took a green signal off, believing on the lateral flow results, which amounted to the serious lack of safety duty protocols towards passengers, which resulted in the which resulted in the failure of the mission space yoga mat, and by bringing a reputational damage by the company itself. Your Honor, further, the retreat cancellation was on the due to the outbreak of COVID-19. Therefore, therefore, the council would also submit that as given in the uh, clause 1 and 1.2 of the agreement, the company must have provided the passengers with an alternative launch date or rescheduling of the flight. By keeping this all situation in the at the consideration with moving ahead without the PCR accurate results, the company had a chance to give a uh, alternative schedule date or postponing the mission, but the company again failed to do so.
Sorry for interrupting there, but we heard from counsel for the defendant that the defendant basically had no choice, that this flight could not be cancelled because if the flight was to be cancelled, they would incur even more damages because they had no other slots to
By
reschedule a flight.
by looking at the Vulcan variant, which was more symptomatic, it is considered as a higher damage and bringing an own harm to the passengers. Then this damage should be given more importance. The health damage of the passengers should be given more importance. That's where the company failed to take a standard reasonable care, the duty of care towards the passengers, as it is again evolved in the common law case Dornick versus Stevenson.
Okay.
Yes, Your Lordship. Your Lordship, thirdly, contractual provisions should be interpreted in favor of Artemis. Your Lordship, Artemis chronic headaches, although persistent, did not qualify under the agreement stipulation as a condition that would affect the fitness in participation. Your Lordship, Article 54 of the DIFC contract law and Article 4.6 of the Unidroit principle talks about the contra pro forentum rules that states contra pro forentum rules that states if a contract terms supplied by one party are unclear and interpretation against the parties preferred. Now, in a very easy format, if I submit Your Lordship, contra pro forentum rule, this rule applies to protect a party who did not draft the contract. And when the clause is very ambiguous, that is potential medical health risk. It is a very ambiguous term which has been drafted in the contract. Your Lord, as
How is that ambiguous? Isn't
potential
COVID a medical risk? What else if not a medical risk? How is that ambiguous?
Your Lordship, she did not foresee or she did not reasonably believe with her past experience that her headaches will be any hindrance in the journey. So that headache would not fall in the category of the potential medical health risk. Furthermore, the headaches were
chronic headache is not a medical
chronic
condition.
headaches. chronic headaches. Your honor, she has been dealing with this chronic headaches for past 5 years, and she has become a very highly influential YouTuber without any hindrance of those headaches. Further, these headaches were not a symptom of variant also.
Famous YouTubers, they're even
So
famous because of their condition. So why the fact that she has a YouTube channel, it doesn't deny the fact that she has a medical condition.
Your Lordship, she has been traveling to the places as a yoga expertise, yoga influencer from a very long time without any hindrance. Your Lordship, if I may give an example, let's say it is very out of context from this fact, but let's say if there is a very national basketball player. Now, a basketball player, there is a leg injury to the basketball, and he's a very highly influential player. Now the leg injury becomes a part of the game. It is a very common injury again to him. It would not fall in the category of potential health risk, and it would not deny him to play the game. Same here again. She has been living with the headaches from 5 years without any being any interruption. Therefore, she did not firmly believe that it will become a potential. She did not foresee that it will become a hindrance in the fitness program. Furthermore, when we see it was not headaches are not symptoms of Vulcan variant also. So based on those facts, when my client was when she waited for the PCR result, and because of the gross negligence of the company, she did not participate in this fitness program. She's not liable to play uh, uh, those counterclaim. Your Lordship, thirdly, when I talk about contra proferentum, again, when I said Your Lord, Your Honor, it disclosed potential medical condition. Now, this principle suggests that if a contract is ambiguous, the interpretation less favorable to the party who provided the wording should be adopted. Therefore, submitted.
You there? Hello?
Hello.
Yes. Okay, we hear you now.
Yes. Yeah, apologies, Your Honor. Therefore, it is submitted.
Less than 4 minutes. So we discussed abundantly the first prong of the defendant claim, and in particular the assumption of liability and the conduct of the defendant. Can we talk a little bit
Yes.
about the prong of the defendant claim concerning the video made on your client's
Yes.
channel angrily describing the full sequence of events? Can you talk about this video? Why? I mean, your client made a video that caused a lot of damage to the defendant. Why shouldn't your client pay for that?
Your Honor, the company is seeking the counterclaim based on the reputational damage. As I've proved, the company was owned by
Okay.
Your Honor, I think she's facing some net issues due to the weather conditions here.
Yes, it's raining outside. Am I audible?
Are you in Dubai? What?
No, Your Honor. In
Ah,
India.
in India.
Okay. Yes, Your Honor. Yes, Your Honor. Further, Your Honor, reputational damage. Now, as a highly influential person, she owes a duty of the information to be provided to all the 27.3 million subscribers regarding the positives and negatives of the mission. She owes a duty of the information towards her all, so that the future risk, so that the people
So
are aware.
I think I understand your point. So you essentially your client was doing a public service, informing her followers about these events. Is there any authority, any relevant authority that that supports your position that this is a valid defense?
Your Honor, Your Honor, it is again submitted that me as a passenger on the retreat, due to the gross negligence of the company and the outbreak of COVID-19, I was made a victim of it, and the counterclaim has been the counterclaim has been is from me. Now,
No, no,
when
no,
I
no.
owed a duty of information.
Sorry, my question was different. I understand your point. So your point is that your client did this video on YouTube, and even if this video might have caused damage to the defendant, your client should not be liable to pay those damages.
Yes, Your Honor, because the company itself has brought as own reputational damage. Therefore, they are supposed to pay the damages to to my client for the cancellation, and not ask the counterclaim from my client itself.
Okay. Okay.
Yes, Your Honor. Yes, Your Honor. If there are no further question, I would like to conclude my. I would submit my conclusion.
Briefly, please.
Yes, Your Honor. Yes, as we see that no, uh, Your Honor, with regard to the counterclaim, it is submitted that Miss Artemis' omission to disclose about the chronic headache was not in bad faith. It was under utmost honesty, and thereby she did not breach any contract. Therefore, she is not liable to pay the counterclaim of 5 USD million to the company. Thank
Okay.
you, Your Honor.
Thank you. Thank you.
Thank you.
We'll hear the rebuttal from Ms. Mitash.
Yes, Your Honor. I have three rebuttals. The first one is that the counsel for the opposition had stated that under Article 5.2 of the agreement that she had to reveal to the best of her knowledge. But in the morning of the trip, she knew that her headaches were severe, and therefore saying that she had no reasonable knowledge of this is nothing but absurd. Now, moving on to my second rebuttal, which is that the council had said the headaches were not a symptom of Vulcan virus. Well, that is incorrect, because under the clarifications given by the DIFC code, headaches were in fact considered as a symptom for Vulcan virus. And even if it was not a symptom, uh, irrespective of it is a symptom or not, Artemis was liable to, irrespective of whether it was a symptom or not, Artemis was bound to disclose whatever symptoms she had, whether it related to Vulcan or not. Now, moving on to my third rebuttal, which is that the Vulcan variant emerged very recently, to be exact, a month prior to the launch date. So it was very new to. So it was last minute that such an issue had came up. So even after considering this last minute mishap, the company still took measures to test people, and also I'd like to state that the company had taken the advice of a professional, a nurse. A nurse is also considered as a professional, and only then the flight had taken off. With
Your
that,
Honor.
Your Honor, I
Counsel, since you have a bit more time left, you have, I think, one.
Your Honor, firstly.
Sorry, Counsel, it's not your time yet to speak. Let Ms. Mitash finish her argument. So you said that your client acted on the advice of a professional, but that professional is a nurse. I mean, how responsible is for a company running, something where people pay 10 million each, where there is a, risk of infection, risk of damages that are very important people on the flight, and they just listen to a nurse.
Yes, Your Honor, I understand, but the current situation deemed for them to seek the help of a nurse because the meteorological window was about to close, and
पापा मम्मी पापा को खुलो आता है
Okay, go ahead.
the meteorological condition was in a way that they had to take a quick decision, and a nurse at the time was the only available professional close by, so they had to check with the nurse before launching.
Okay, thank you.
It was the best possible way to do it at the moment. Thank you, Yamal.
Thank you, Counsel. Ms. Jane, should rebuttal?
Your Honor, 1 second. There are weather conditions are not right here. One second. Your Honor, am I audible?
Please.
Yes, Your Honor. Regarding the first rebuttal, Your Honor, it is explicitly given in the page number 6 that Artemis wanted to get back, though she had headaches at the launch date, she wanted to get back the results for her PCR test, but she was informed that due to delay at the labs, which was again the company's fault, and the test result would take more time. Now, at this point of time, the company would have waited again for the by looking at the situation at the consideration. Your Honor, secondly, as I said, the headaches, as the junior defendant is stating that it is a part of has been facing since 5 years, which is not new. Again, she did not show, other than headache, she did not show the other 12 symptoms, which were very important to the this. So headaches as a new COVID symptom, she did not foresee that it could be a COVID new Vulcan variant symptom because she has this headache from past 5 years. Thirdly, Your Honor, with regard to the reputational damage, sorry, I could not hear the third rebuttal, Your Honor. Could they repeat it?
I didn't say anything.
The third rebuttal, Your Honor.
You want me to say what?
Sir, Your Honor, the third rebuttal.
The what?
Point. By the third rebuttal point by the
Yes, you have time.
No, sir, I couldn't hear it because of. Okay, Your Honor, by looking at all the rebuttals, the PCR results again, as I mentioned, the eligibility of the doctors because the company, if they are taking a highly risky space yoga mission, they could just not rely on the information of the nurse, but on the eligible doctors, which was very important at that point of the time. And as I again mentioned in 1 and 1.2, they had a choice to provide for an alternative date or reschedule of the mission. That was they were supposed to do it, but they did not do it. Therefore, it was their own negligence, their own willful misconduct towards their passengers. Therefore, she is not liable to pay any of the counterclaim by the company.
Okay, thank you.
Thank you, Your Honor.
Thank you. Okay, so I think this concludes this round. Thanks, everyone. Is anybody from admin here? Shitaki?
I think we should give him feedback, no?
Yeah, I don't know. Anybody from the organization here?
I don't know exactly.
Okay. I was wondering if in the previous round, so how did the other judges do? Did it give feedback first?
Sorry, I didn't participate, Rodrigo.
No, I know. I'm asking to the. Did you do a previous round? I assume they did, right? I'm asking the participants. In the previous, did you participate to another round, or is this your first round?
This is the second round, Your Honor.
Okay. In the previous round, did you receive feedback immediately, or did they
Your
ask you?
Your Honor, this is our first round. There was another round before us, which was with other members. But I
Okay.
believe
I
there
think
was a feedback
I think
given.
the best way to Badreddin, let me know if you have a different ideas.
Yeah, yeah,
I
yeah,
think
okay.
it's good if we first we deliberate, you and I,
Okay. Yeah.
and then we ask everybody to come back. Normally there are breakout rooms. That's why I was wondering if there was anybody from the organization, but since there is nobody. So can I ask all participants to log out? Now it's 4:20 and log back at 4:25, so 5 minutes.
5 minutes.
But then you stay, of course. You
No, no,
immediately
no, no. We have a separate room,
we
Rodrigo.
have. How do
Yeah,
we
yeah.
do that?
So we leave and go to the judge room.
How do we go there? Do you know how do we go there?
Yeah, but so 1 minute. Okay, okay, okay. Technically, okay. Uh, you should look out. Do you hear me,
Yeah, but
Rodrigo?
how do we go to the breakout room?
Look out. Go again to the Webnyay platform and then choose judge room.
Okay, I will do that. Okay, so we log out and then
Yes, yes, yes. Okay.
Shitraki, no, we cannot hear you. Shitraki?
Hello?
Yeah, now yes.
Yeah.
So do you know, understand from Badruddin that there is a breakout room for us, for the judges?
Yes, there is a breakout room that you can join. Otherwise, what we can do is, if the session is over, then the participants can leave this
No, what we
room.
would like to do, we would like to take 5 minutes to deliberate
Okay, then
separately, and then we join back.
all right. I will share the link right here on chat, and then you can click on the link and join the breakout room, and then join back in this particular hearing room.
Excellent.
Will
Yeah,
that
let's do
work?
that. Yes.
Okay. All right. I'm just pasting the link on the chat.
Okay, got the link. Okay, so I
Yes.
don't know sure if Badruddin is here or not. Okay, Badruddin, so we enter in the link, we enter in the room. For those participants, uh, please wait us here in this room. We will join in 5 minutes.
Yes. I have pasted the link
No,
to the
no, yeah,
judges
yeah, no,
web.
thank you. I was talking about with the participants. So participants, please wait us here.
Sure, Your Honor.
Okay, in this room, we quickly go to the other room, and then we will come back. Okay, 5 minutes. Thank you. Okay, hello everyone. We're back.
Hello, we come back.
Yes.
Only you. Yes.
Hi. Just checking everybody is here. Sorry, took us a while to find the judge room.
Okay.
Okay, so we have Kelsey, we have Manish Jane is here.
Yes, yes, Your Honor.
Ah, you there? Very well. Istra is here. I can see you, and I can also see you very well. Okay, so I would say before we start with just to make a quick introduction ourselves. I'm a senior associate at Horizons & Co. in Dubai, which is a Emirati law firm, and I specialize in DIFC litigation and arbitration. So I appear before this court very often. And Badruddin, you want to introduce yourself?
Yeah, thank you. I'm Dr. Badruddin Birhliya. I'm assistant professor at Faculty of Law, Baji Mukhtar University in Algeria, as a professor of civil law and commercial law. And in parallel, I'm a lawyer at the Supreme Court, also in Algeria. Sometimes I move to Sharjah as a visitor. So I'm happy to participate with Rodrigo, the president of this court. And I hope you all the best and good luck for your participation. Okay.
Okay, so let's start with the feedback. I will be brief. Maybe we can start and then building. Of course, you can provide your feedback as well. Actually, let's do one by one. So let's start with Kerti. Okay, so one thing I noted, there are two things probably that I noted importantly. One, you raised the point of force majeure. Again, you are rebutting a possible defense, which is a defense that the defendant has not even made. So, as a general matter, there is no need, unless it's already on the record. For example, there is something already on record. If there is something on the record which is bad for you, it's your duty as an advocate to address that. You'll say, Your Honor, yes, this happened. Yes, there is this argument, but this is not important. Here, nobody ever mentioned force majeure. So there is no need to include force majeure in your argument unless somebody mentions that. Then the clause about the 1 million limitation liability. You're a little bit avoiding my questions. I got this impression they were trying to debug my question. If the court asks you a question, you need to answer. It might be that you don't have the answer, and you can ask for time, or you can ask, for example, for the answer in rebuttal. But the worst thing that you can do is to give the impression that you're trying to avoid the answer, or to give the same answer without getting to the point. Because otherwise, the court might get the impression that either you don't understand the question, or that you want to avoid the question. So try to be mindful of that. And then the other two minor points, the standard of proof. You kind of shot yourself because you said the standard of proof is the standard proof of no, sorry. No, sorry. So a different point. You quoted the UNIDROIT principles. That's a general point, not only you, but I noted this also in your presentation. So and I know that the difficulty of this problem is that there are very short facts there, no law at all, and I think the organizers expect you to prepare and research your law, and of course, this is a difficult system that you might not study law school is difficult to understand if you're just starting out. I acknowledge that. But as a general matter, if you're dealing in this jurisdiction, in any jurisdiction, always start with the authorities, with the binding authorities. What are the binding authorities on this jurisdiction? First of all, the statutes, the laws, the contract law, the law obligations, the law of damages and remedies. Start from that. So this DIFC is a strange jurisdiction because it's a mix between civil law and common law, because the laws are written, you have statutes, but these laws are interpreted as in other common law jurisdiction. So like in a pure common law jurisdiction, you will do the same thing. You will look at the judgments or a statute that exists. Even in the UK, there are statutes on all things. So always start from the statute if there is a statute, and then you can quote persuade soft law authority, for example, the principles, or for example, a precedent from another jurisdiction. But always start from the authority. That's all for me on KRT. Badruddin.
Thank you, Rodrigo. I just have one common feedback. So when you give your presentation, you should be convinced by your argument. So when you do this, therefore you could transfer this conviction to the court. That's the skills of the lawyer. So sometimes when you use some terms or expressions such as I believe, I think that this.
But there was not kept, I think.
Yeah.
Or someone else.
I believe. Okay. So yeah, it is submitted. It's submitted or something like this. So that's all, and I don't want to repeat what Rodrigo said. I just want to tell you good luck. Okay.
Okay. So next we go to Ista, and I think she was thinking about you. So remember, when you make submission, you're not a scientist, you're not an expert, you're a lawyer, right? So you represent your client, you present arguments, you make assertions of fact or assertions of law, and you submit those arguments. I submit, I propose, I submit for the right. Never, I believe, I think, or even when sometimes people, when they quote a contract, say, I believe it's probably this clause. No. The court, you'll get the impression that you are not prepared, that you know the contract. If you quote something, be precise. It's a duty as an advocate to be precise, to be accurate. It's a standard of diligence as counsel when you appear as an advocate. Then the another thing I noticed is that you there was not really a clear order in your argument. So what normally you're expected to do as when you start, first you say, Your Honor, I will address 1, 2, 3, 4 points. These are my points, and then you discuss the points in detail. I don't think you did that. You should give an outline when you start. Then I ask you a question about lost profits. When I was asking about lost profits, and that's again a question. I think it's a point for everyone, and I saw this also in my previous round. Don't confuse liability with damages or with quantum. So one thing is to say you did something wrong, you breached the contract, therefore you're liable. That's the first point. The second point is you're liable, then what? Then you can be compensated for this, for this, for this, and for this. Why are you entitled to this, or not? So I ask you a question about lost profits. I ask you, is the claimant entitled to lost profit? On what basis? That's where I was going to, and that's what I expect you to tell me. To say, even if my client is liable, even if my client did something wrong, still should not pay for lost profits because it's not in the contract, or because it's not in the law, or they should be restricted. So make this distinction. You're always responding about liability. These are different points. Again, and that goes to the same point about answering questions. Nobody expects that you know an answer to everything. You can try to provide an answer to something if the answer is reasonable. If you think you don't really have an answer or you don't know, that's fine. You can tell the court. Actually, you can tell to the court, I will address this point later. They usually, even barristers do this. Even very senior lawyers, even people that do this for 30 years. Sometimes they don't know everything, and they might have a younger colleague that helps them, gives them the answer, tells them what to say. And the way usually to resolve this problem is to say, Your Honor, I would like to address this point later, for example, right? It's an excuse to take time. But don't dribble the question, answer the question. Or either you answer the question or you say why you're not answering the question. Dribbling the question or giving an irrelevant answer is the worst thing you can do. Badruddin?
Again, I will give a common feedback. I don't prefer to sit anyone from the participants. So you should avoid to repeat your arguments. So you should move to the details or to another argument. That's all. And I give you the floor, Rodrigo, for.
Okay. Then we have Dia. Okay, Dia, so I think you have the right tone, especially when you started. After the questions, you got a bit confused. But I like the way you started. You gave a roadmap. I like that you said I start from the second ground because it was clear to you that we were not interested in the first ground. I like that. You started very well, and you have a good pace, a good inflection, a good mode of speech. So this is good. Then you were a little bit confused on the content of your arguments. For example, there was these questions about misrepresentation. Don't confuse. And again, I acknowledge that there's a lot of material, a lot of law to be learned here. So for your information, it is possible to rely on the law of obligations even in contract cases. And misrepresentation is the perfect example. Don't confuse defenses with grounds for claims. So you quoted fraud in the contract law. That's out of place because that is a defense. That is a way to escape from the contract. Here you're discussing the counterclaim. So you're trying to convince the court why your client has a counterclaim and why this counterclaim should be awarded. So your argument should be based, in this case, misrepresentation is a good one, and you should know very well what the DIFC law obligations and the DIFC law of damages and remedies says about that. And I think
Rodrigo,
the last, yes.
We have only 5 to 7 minutes, huh? For feedback.
Yes, okay, yeah, be quick. The last thing, I think eventually you took a little bit more time. If the court tells you stop, you have 30 seconds. You have 30 seconds. Otherwise, you will really irritate the bench. So if you need to stop, you stop. Badruddin?
Okay, no, I just finished. I have no other comments.
Okay, and last one for Manisha. I hope all is good with the rain. And then I was asking if you're in Dubai because we had some problems with the rain as well, as you might be aware. So first of all, when you present, be relaxed, calm. Don't scream. Your tone of voice was very high. Try to tone it down. Then there was one point about case that you quoted and asked you from what jurisdiction. If you quote a case, you need to know it by heart. If you quote a case, you need to know who rendered the judgment, from what jurisdiction, what the case is about, and why the facts. It's not enough to copy one phrase in a long judgment. You need to explain to the court why the facts of that case are similar to the facts of this case, and therefore why this is persuasive authority. In this jurisdiction, basically anything which is not DIFC Court of Appeal is only persuasive. There are two levels in the DIFC. There is first instance and Court of Appeal. Court of Appeal is binding. First instance is persuasive but not binding. Anything else from the UK, from the United States, from Japan, from France, wherever you want, is just persuasive. So if you quote a case which is not on the DSC, you should also tell me why this case is important. I think you discuss the case. I don't think you explain why the case is important. And last point, since we are short on time, there was one questions about why your client was justified in doing the YouTube video, and your response was because my client had a duty to her followers, to inform her followers. That's actually a good answer. It's a good point. But then I ask you, what is the legal ground? And you didn't have an answer to that. So this is a good point, it's a good response, it's a good idea that you had, but try to think what is the legal basis of that. Okay? That I think that's all. I don't know if Badruddin and anything to add.
Nice to meet you.
Okay.
Thank you, Your Honor. It was pleasure on Discord.
Pleasure for me as well. Sorry if it took a little longer than it should have. And best of luck with this Moot and with your career.
Okay.
Thank you, Anna.
Thank you. See you, Rodrigo.
Bye-bye. Thank you.
Bye-bye.
Thank you.
Thank you.